arrangements are ongoing?
Well, I think, Minister, well, firstly, thank you for informing me that there is some movement that has started to happen from the side of the executive about our proposal. Of course, we would have liked that it didn't take more than 7 years. But I understand like a lot of things in government, things take long. But hopefully once you are ready, we can speed up the whole process so that we don't wait another 7 years. Certainly, Minister, the current arrangement in regard to that issue is better than what was there before, So it's better, but we would have preferred that by now we would have gone beyond that, we would have gone to phase 3, as I indicated, so that it's a matter that's really within the judiciary. But it is an improvement. It is an improvement.
On the second one, what is your view on the operationalization of Section 29 of the Superior Courts Act? I'm not sure if I should rephrase it just to remind you what it is about.
Yes, because I don't have the act in front of me.
Oh, okay. It is the one that deals with the rules of the Constitutional Court, the making of the rules of the Constitutional Court. The Chief Justice, after consultation with the Minister, makes rules relating to the manner in which the Constitutional Court may be engaged in a manner, including the matters referred to in Section 172 of the Constitution, all matters relating to the proceedings and before the court. It's about that. And I think you will remember that there have been issues raised from the heads of courts and the former CJ why it should not be operationalized and so forth.
Yes. No, certainly the position is that the rules of courts should actually be dealt with by the judiciary. And there is, in my view, no reason why the executive should really be involved. But we know our history in terms of rulemaking in South Africa. But certainly the rules of courts, all courts, should be made by the judiciary.
Yeah, maybe on that regard, Acting Chief Justice, as you are aware that most of the rules have to go through Parliament and so forth. And there is a role for the public to play.
Yeah.
So, and Parliament has the mechanisms of involving the public. If it's only the judiciary, how are we going to also ensure that the public plays a role in the rule participation, in the rule-making process, and also the mandate of the executive, which is to ensure that there is access to justice, which is not really interference to the court, but we do have a mandate with regards to access to justice.
Well, I don't see why, if as a principle, it is accepted that the judiciary is the proper arm of government to make rules about its own operations, which is the courts, why there should be any impediment in the judiciary being able to invite the public to comment on, for example, rules that it wishes to make. You will remember that if I recall correctly, when for a number of years, the rules of the Constitutional Court were simply the power to make them lay with the president of the Constitutional Court. If you look at the commission, for example, you refer to the commission. When the commission started, I had to make rules. They didn't need to go to Parliament. I consulted those that I needed to consult, and we made rules. They got published. So if we wanted, well, we didn't invite comments, but if we wanted comments, they could have been published, and we wait for comments from the public and then make final rules after that. So I see no reason why, for purposes of receiving comments from the public, they would necessarily need to go via Parliament.
Yeah, the other arm of ensuring access to justice, which it's vested with the executive on the process of rulemaking. How will that be managed through when it's only the judiciary dealings with the rules making process?
Well, I would not. It's a question of what they do. I would not say they don't need to make an input, but if they make an input when everyone is allowed to make an input, or they get consulted as a stakeholder, they could get consulted. I don't think that there would be a problem. Then the judiciary would make the rules after being fully informed of whatever concerns may come from the executive or Parliament. Because they could say, for example, no, these rules impede access to justice, so we suggest that they should be dealt with differently, which is what happens and has happened before, when even legislation that affects the judiciary gets made, because obviously legislation will be made in Parliament. Only Parliament can make legislation. Even when it affects the judiciary makes representations to say, in our view, this is what this legislation should say, this is what it should not say. And obviously, the minister responsible for that legislation or Parliament, they might take a view that is different from the judiciary. So it happens in relation to legislation that even though we are the ones who are affected by the legislation, but we make representations, and sometimes Parliament and the executive agree with us, sometimes they don't agree with us, and when they don't agree with us, we accept that they don't agree, and it doesn't happen. So I think a lot depends on all the arms of government trying to cooperate and work together to achieve these common goals of access to justice.
Yeah, on the issue of digitization and modernization, Acting Chief Justice, you are aware you have launched it, the former Chief Justice, you have piloted the program in Gauteng through Caseline, and you are now moving to. What has been your role with modernization, and what is your view if you are appointed as a Chief Justice to carry this vision forward? I can state that I have seen the good work you have done in the commission. You are leaving us now with the legacy of a data center, which I think it will go a long way to help the country in the fight against corruption, but also to digitalize and modernize the entire criminal justice system.
Thank you very much, Minister. I might not myself be very good with IT, but I embrace it wholeheartedly. It's very important. It's the way to go, and that's why in the commission we have the system that you are talking about. So I'm aware of what has happened, and I'm aware of the pilot project. If I am appointed, I mean the judiciary, it's a heads of court project. If I'm appointed, I will continue with the arrangement that the former Chief Justice had and the heads of court had, namely, they have a committee that has been specifically dealing with that, that reports back to the heads of court and reports back to the Chief Justice. I would give that committee whatever support they have. I would not want to change things because it has done a good job. It is led by Judge President Mlambo. It has done a good job, and I would want it to continue.
Yeah. In terms of rolling out throughout the country, including magistracy and so forth, that is what I wanted also to get going forward, if you are appointed.
Yes, no, I would like that to happen, and short of challenges of budget and so on, if there are no challenges, I would want that to happen as soon as possible.
Yeah. Lastly, it's now as an acting Chief Justice, and also in case you are appointed, you will also chair what is called a small JSC.
Yeah.
I could hear from acting President Petzer that you have known each other for many years. It looks like as colleagues and as judges,
Yeah.
you are a family that knows each other. How are you going to deal with matters when a colleague that you know very well, you have been together at school, university, and maybe in practice? How do you deal with such issues and you ensure that you lead from the front? You are not always recusing yourself from those proceedings. I do understand that there could be times where you might have to, but how will you deal with these difficult issues of helping to discipline or dealing with issues of misconduct of your colleagues that you know very well?
Thank you, Minister. That's a very important question. Well, the starting point, Minister, is this. The handling of complaints against judges by the judiciary is a very important principle. In other words, that we judges are the ones who must discipline our own colleagues is a very important principle. I certainly would not like a situation where we get disciplined by other people. Of course, I accept, as I have to, Minister, that when all processes relating to the discipline of judges have been exhausted, if we are dealing with a case of impeachment, it ultimately happens in Parliament. But the prior process happens within, firstly, the judiciary. So for that principle to be maintained, judges have to accept that to a very large extent, they are called upon to adjudicate matters of discipline involving people that they know. Of course, there will be cases where you are too close to somebody, but otherwise you are dealing with matters of people that we know. After all, the community of judges is not a big community. So one, that would be my stance. But I must also say, Minister, I would not be new to that, because after I had been appointed as Deputy Chief Justice, the former Chief Justice told me that as Chief Justice, he would not chair the Judicial Conduct Committee because he chairs the JSC. He said he didn't want a situation where he would not be able to chair the JSC because he chaired the JCC when it dealt with a certain disciplinary matter relating to a particular judge. So it is better that the DCJ should, for all intents and purposes, be the chair of the JCC, but he basically becomes acting chair because in terms of the act, the Chief Justice is the chairperson. So I have been involved there. Maybe I can take this opportunity to say this, Minister. When I came to the position of DCJ, there was a huge backlog in matters relating to complaints against judges. And I looked into why there was this backlog, and I looked into how the system worked. But to cut a long story short, I ended up sitting down and trying to understand the act properly and preparing a document that would guide judges, heads of court, because one, I realized that the act had a role for heads of court to be involved in these matters, but up to that point, they were not so involved. So, and I said, well, first of all, those matters that we can give to heads of court to deal with, we should give to them so that we can deal with the backlog. And I spoke to the heads of court and they embraced the idea. I gave them the document that would guide them how to handle this. And since then, the backlog has been sorted out. Well, I haven't spoken to the secretariat recently, but the last time I knew, the backlog was sorted out, and the heads of court are playing a very important role. But to go back to your question, I have sat in a matter in the Judicial Conduct Committee. It was an appeal with two other colleagues involving one of the heads of court. And of course, heads of court, we meet, we know each other, all of us, where we came to the conclusion that he was guilty of certain unacceptable conduct. And we decided that the appropriate sanction would be a reprimand. And we asked him to present himself to the JCC for purposes of us administering the reprimand to him. He accepted the outcome of the JCC. He came. Of course, he might not have been happy with some aspects or whatever, but he accepted the outcome. He came to us, availed himself. It fell upon me as the most senior of the panel to administer the reprimand to him, and he accepted. So I think that judges have embraced this system, and they accept that we have to make these decisions against people that we know. So I think it will still work, Minister.
Thank you, Acting President.
Thank you, Honorable Minister. JP Tlaletsi.
Thank you, Acting President, and good day, Acting Chief Justice.
Good morning, Judge President Tlaletsi.
Oh, thank you. I take it the reprimand was not 6 strokes with a light cane.
No. The reprimand was verbal.
Oh, I see. Incidentally, one of those as early as 2004, you called to the Labor Court and took me through the ranks, and until today, the rest is history. But then, from what you've discussed with the minister just now, it's my turn to grill you, nevertheless.
I accept, Judge President Tlaletsi, that today I'm subject to being grilled by everybody here.
Wonderful, wonderful.
And I think there are some who are just saying, when am I getting the chance?
Thank you. Thank you. I won't be long, Acting Chief Justice. Just two issues that I want to raise with you. I'll put them, the two of them to you, and then I will give you the opportunity to respond. Well, the first one, which is linked to the second one, I think a chunk of your time was taken by the commission in the past few years. And if you would explain how did you manage to juggle between the commission and the court and your functions as the Deputy Chief Justice? And the second one, which I said is linked to the first one, is structurally, the Deputy Chief Justice is not necessarily a member of the heads of court, comes on invitation or as an alternate to the Chief Justice. In your view, would you not consider, if you are appointed, to have the Deputy Chief Justice to be part of that structure in whatever role, so that because you'll be, the Deputy Chief Justice is for the whole country and not for that particular court. And we might cause the Deputy Chief Justice to limp if he's not part of the day-to-day functioning and meetings of the heads of court. And then the second issue,
Yes.
yeah, I would want you to share your views on the language policy. We know that you have the official language policy of the courts, and if you've got any views, if you are the Chief Justice, whether we need to revisit that, what needs to be done, we need to improve it. Thank you.
Thank you, Judge President Tlaletsi. Let me start with the question relating to whether the DCJ should not be part of the heads of court. Now, you may be right that the DCJ comes to the heads of court by the invitation of the Chief Justice or in the place of the Chief Justice when the Chief Justice is not available to attend. But for some reason, I was not thinking about it in that way. In my mind, it was as if it has become established practice, but I may be wrong. It arises from my knowledge of how it came about. As you know, I was part of the heads of court for close to 11 years when I was heading the Labor Appeal Court and Labor Court. So some of the things I have that institutional memory of how they came about. For example, Justice Charles Carlson originally didn't come to the heads of court meeting with Justice Langa, who was his deputy. At that stage, the president and deputy president of the Constitutional Court, I think the position of Chief Justice had not moved from the SCA to the Constitutional Court. And when Justice Charles Carlson's term was about to end, he spoke to us as heads of court and asked whether it would not be a good idea for him to start bringing in Justice Langa to the heads of courts and not wait until his term had ended, so that he could get to be involved. There could be, he could get to know how heads of court operate. And we agreed. That's how Justice Langa then came in. But when Chief Justice Langa became Chief Justice, I think the then Deputy Chief Justice, Justice Musimege, may or may not have come a lot of times to the meeting, so you may be right in how you put it. But I do know that at some stage, the Chief Justice Langa had asked the heads of courts about bringing him. And the heads of court had said it's fine, but I don't know what happened. And when it was Chief Justice Ngobo, I don't remember that Deputy Chief Justice Moseneke was brought in. So I think probably you are right. My recollection was wrong. I don't think that there is a practice. Probably it's just an invitation. But my view would certainly be that the Deputy Chief Justice should be part of the heads of court. So if I'm appointed as Chief Justice, I would invite the Deputy Chief Justice to be part of the heads of court. And if there's anything to be done to make sure that it's not by invitation, maybe I would consider. But obviously it is a matter that would need to be placed before the heads of court for them to give their views. That was the one question. The second question, or the first question, related to the fact that I, for some time, was in the commission, but being Deputy Chief Justice at the same time, and how did I handle that? After I'd been appointed as the chairperson of the commission in January, February 2018, while we were putting the infrastructure of the commission in place, and while I was assembling the investigation team and the legal team and looking for premises from which the commission would operate, I was able to sit in matters in the court until I think about a month or two before the commencement of hearings, which commenced in August. Once we were 2 months or 1 month before, I then stopped sitting in matters by arrangement with the Chief Justice, obviously. So I did not sit in matters since the hearing started until the public hearings had been completed, and I went back. But what happened was that the Chief Justice involved me in other leadership matters and not sitting in court. You will be aware that I would call colleagues from other courts that we were inviting to come and act in the constitutional court. So he allowed me largely to play that role, but he consulted me a lot on leadership matters and other matters during that time. That is what happened. With regard to the language policy of the court, you probably remember that I chaired a committee many years ago when I was Judge President of the Labour Appeal Court. I think it was under the leadership of Chief Justice Langa, if I'm not mistaken, I'm not sure. When I chaired a committee of the heads of court that consisted of myself, Judge President Hlophe, and Judge President Homo. We had been asked by the heads of court to look into the issue of the language of record, and we had a split. There was the minority view that said it must be English all the way, and there was another view that was Judge President Hlophe and I took a different view and wanted to have a bigger role for African languages, indigenous languages, while still having English. But the matter was discussed by the heads of courts, and no agreement could be reached. I think we couldn't reach agreement, But what happened was that after Chief Justice Mogoeng came in, he then sought to make sure there was finality on that issue, which had been pending for a long time. And it was then agreed that English would be the language. And I've accepted that decision. I have no intention, if I get appointed as Chief Justice, to try and want to change it. I think it's a decision that must continue.
Thank you, Chief Justice. Thank you, President.
Thank you, JP Tlaletsi. Commissioner Singh.
Thank you very much, Acting President, and good afternoon, Acting Chief Justice Zondo.
Good afternoon, Commissioner Singh.
Good to see you again.
Thank Yes, the issue of security for judges and judicial officers has been quite a critical issue. Well, myself, my family and I, all kinds of threats have been made against me and against my family, arising basically from my work in the commission. But the state has provided protection. During the July unrest and for some time after that, there were threats against judges in general, and various concerns came from judges, and the matter was discussed. I convened a heads of court meeting, a virtual heads of court meeting. We discussed the matter, and the security, the SAPS and other security agencies were quite concerned. Arrangements were made for some protection to be given to justices of the Constitutional Court and justices of the Supreme Court of Appeal, as well as judges president, if I recall correctly. But there were some judges who said, and then it was arranged that if any particular judge faces a specific threat, they needed to communicate with their judge president or head of court, and then arrangements could be made. But there were some judges who preferred not to have that kind of security for certain reasons. But yes, there have been serious threats, and protection is necessary to be given.
Do you think the state is doing enough in terms of providing the protection, not only to judicial officers, but to people like whistleblowers?
Well, I don't have enough facts in terms of whistleblowers, but from what one reads in the media, one is very concerned about whether protection is given. And I believe very strongly that if we are going to have any chance of making a dent on corruption in this country, we must make sure that we protect whistleblowers. because those are the people, together with investigative journalists, who really give us information. The work of this commission, of the commission that I chair, would have been much more difficult had it not been for the investigative journalists that we have in this country and the whistleblowers. I'm indebted to them. I think all of us as a country should be indebted to them. And as a country, we should do whatever we can to provide protection to them.
Thank you for that. Acting Chief Justice, there are many elephants in this room, including the one elephant from the IFP that's asking you questions. But I'll just touch on a few of them, because I can't touch on all of them. One is the concern and the objection with regard to section 176(1) of the Constitution, the term of office and the time you have left in office. And I think you know what the concern is. If you are appointed as Chief Justice, would you be able to fulfill your aims and ambitions and introduce innovation into the entire judiciary within the short space of time? Because earlier on you said you would try and do this and try and do that. But I'm also saying it in the background that you've had the experience so far as acting Chief Justice. And one would imagine that you'll hit the ground running if you are appointed as the Chief Justice. Would you like to comment on this objection before I touch on any other objection?
Yes, no, thank you very much. I appreciate the opportunity to deal with this. If I'm appointed, I will have about 2.5 years to work as Chief Justice. Chief Justice Ngobo had less than that. He had less than 2 years. But within that short space of time, he made a very big contribution, one of which is getting the executive, President Zuma, to agree to establish the office of the Chief Justice as a national department. That was a very important step towards complete institutional independence for the judiciary. There are other measures, but also I just need to say, a colleague sent me some information some time back. Unfortunately, I don't have it here. He had a look at how long Chief Justices in this country stayed in office. I think he went up to the 1800s, and he did that research. And when one looks at that research, one finds that it was not unusual to have Chief Justices who served for 2 years or 3 years, less than 5 years. I looked at the list there were many. Number two, he said, or that research revealed that the immediate past Chief Justice who served as Chief Justice for 10 years was the second person, Chief Justice, to serve that long during that long period that he researched. So there is that. So from my point of view, I think there are a number of things that I can do, and one of them is really to see whether I can't achieve an agreement with the executive about phase 2 and phase 3 that we talked about. And if I could achieve that, I would be very happy when I leave office as Chief Justice, because I would know that I have been able to leave behind a judiciary that has achieved that complete institutional independence, which is very critical. But also a number of things that I think need to be dealt with are things that don't need many years to achieve. I talked earlier on about how courts are struggling to have things dealt with that they should have dealt with easily. Certain courts, the buildings are in a dilapidated state, lifts are not working, and so on. So what one needs there is to get all the people concerned and try and find a way to make sure that when these things are sorted out, too, when they recur in the future, they are dealt with differently than they have been dealt with in the past. But also during this time, one could make a number of contributions in terms of transformation, in terms of how the court works. So I believe that's important. But also, I think there is a good reason, and you probably should agree with me, why, in terms of our constitution, the term of office of members of parliament is five years. The term of office of a president is 5 years. There's a reason for that. You don't want a president who is going to be there for too long. You want to be able to see whether at the end of the first term he is still worthy of being given another chance, and so on and so on. The voters need to see whether they should not change and elect another party as the majority party to handle government. So we had, with regard to the immediate past Chief Justice, we had a Chief Justice who was there for 10 years, and it worked well. And it might work well with anybody in the future who could take a long time. But you don't know. We don't know. So it may, but one of the things that would happen is that if I were appointed as Chief Justice, the position of Deputy Chief Justice would become vacant. And obviously, the President would exercise his prerogative as to who he nominates and so on. But if I'm appointed as Chief Justice, the fact that my term would be 2.5 years might not really be a bad thing. It might well be a good thing, because it may be that at that time, then maybe you could get somebody who could stay much longer. But we have had a Chief Justice who was there for 10 years, and obviously the President will exercise his mind. So I think that 2.5 years has certainly happened. I mean, less than 2.5 years has happened with the Chief Justice. In terms of the study or research that I'm talking about, there are a number of Chief Justices that served 2 years, 3 years, and so on.
Thank you for that. ACJ, you've been part of this panel on a number of occasions, like some of us commissioners, and we have been appointing people who are younger, even to the Constitutional Court, and as judges. Do you perhaps think, in your personal view, that Parliament needs to relook at this 12-year clause, because Parliament can change that in terms of the Constitution?
I know that the former Chief Justice has a very clear view of that, and his view is yes, it should do so. My approach would be that there is nothing wrong in relooking at the matter, The question is what you do after relooking. Do you change or do you leave it? Because when you relook, you reconsider the pros and cons. Now, my starting point would be, let's go back to the beginning. What was the rationale for limiting the term of office of justices of the Constitutional Court? If that rationale no longer holds, then it's fine. I think it can be changed. But if that rationale doesn't hold anymore, if it doesn't hold anymore, changes can be made. But if it still holds, then we shouldn't. But when we look at something like that, we need to accept that those who came before us, they may have had certain wisdom in why certain things should happen in a certain way. So we must think very carefully. So I'm not saying it should not be changed. I'm not saying it should be retained, but I think it would depend on a discussion of the issue, saying what was the rationale initially? Does that rationale not hold anymore? But it is true that we have had situations where justices of the Constitutional Court have retired, so to speak, early when they still have a lot of years that they could contribute. But it may well be that when this body recommends or puts in a list to the president names of judges from which the president must appoint to fill vacancies in the Constitutional Court, it must bear the issue of age in mind and maybe say somebody who might be too young must collect more experience in other courts before going there to the Constitutional Court, because if he goes there too early, he or she will come out too early while they have a lot to contribute. But it is this body that might have to consider. There might be other counter arguments that must be looked at. But I proceed from the view that says there was a rationale for doing it. We can look at it and ask the question whether it still holds or not.
No, thank you. I think we certainly have our work cut out as members of the legislature in that regard.
Yes.
My last question would relate to some of the other objections that have been filed. Now, there have been many letters supporting your nomination, and you must have gone through them. But there have been those with serious, quote unquote, serious objections, which I think you must be afforded the opportunity to respond to.
Yes, yes.
Some of those that have written have accused you of a pro-Ramaphosa bias. There are others, and I saw the objection from former Director General Arthur Fraser. That's the second one. And the third one that I listed here was an objection from one Mr. B. Swane. It's on page, it's objection number 7, I think, or one of them. How would you like to respond to some of these three objections in particular? And I know there are other objections, which I think other commissioners will deal with. Thank you.
Well, I certainly remember the one from Mr. Fraser well, and I will deal with it. But let me deal with those that you label as accusing me of being pro-Ramaphosa. I don't think that they place any facts to support what they say. It's just their perception as I see it. I'm not pro anybody. I'm not anti anybody. I made the decision as chairperson of the commission way back in 2018, for example, I think second half of the year, that President Ramaphosa would have to appear before the commission because he was part of the executive during the time when these allegations of state capture happened. He was deputy president. He was deputy to President Zuma. He was deputy president of the ANC. And I made an appointment with him as a matter of courtesy to say to him, that is the view that I took. So he must know that I would not consider, I did not think that the commission would have completed its work properly without him coming to the commission and answering questions and giving evidence. And he did not take long when we had that meeting to say he agreed. He said, DCJ, I agree with you. I must come to the commission and account. He did not give me any problems. And of course, he did come. So I made that decision, and I made that decision alone that he would have to come. And he came and he was asked questions. So, of course, Commissioner Singh, through this commission, I've made a lot of enemies for myself. But it's not as if I did not know that taking this kind of job would land me in that situation. I knew. When the Chief Justice had been asked by President Zuma to find a judge who would chair this commission in accordance with the remedial action of the public protector, he called me as his deputy and told me that there was this task. And we had a discussion. He asked me who I thought we should approach. And I can't remember whether I gave him the name, some of the names immediately, or I said, I will reflect, and we talked later. But we talked, and I proposed some names. He had some names, and he gave me the task of phoning those judges to try and find somebody who would chair the commission. And the matter was urgent from the point of view of President Zuma. Some of the judges were not available. Others were not comfortable with taking this job. So as we were phoning and talking to people, when we were in the same room on this particular occasion with the Chief Justice, and I had proposed a certain name of a retired judge, he called that retired judge. And from the conversation, I could tell that the retired judge was not available because of other commitments. And he said something which made me think I was going to be the next he was going to ask. So while he was speaking, I had to think what my answer would be. And when he finished, he told me that no, that retired judge was not available. Then he said, what about you? I had no hesitation in accepting the responsibility. I said to him, Chief Justice, if you want me to do it, I will do it. I had realized how it might be difficult to find somebody who would accept this responsibility. I was number 2 in the judiciary. I was the Deputy Chief Justice. There was no way I could run away from responsibility. As I say, I knew that it was going to be difficult. I knew that I would make lots of enemies if I did this job properly, but I accepted that it was a job to be done. And if I made enemies for myself in trying to help the country, so be it. I knew all of this. I can't say that I didn't know. I explained it to my family. I said, lots of things could happen, but we will have to hope that everything goes well. even now, with all of the things that have happened, if I was asked to undertake a serious task that could mean putting me in a difficult position, if it had to be done, I would do it. So I'm sorry to give you a long answer, Commissioner Singh.
So you accepted the poison chalice.
I did.
Chair,
But let me,
sorry for the interruption. Could I ask a follow-up question when the time is right?
Noted, Professor Slim.
thank you. Then, Commissioner Singh, let me deal with the question, with the objection from Mr. Arthur Fraser. You probably would have seen the response that I gave to the panel when he had raised his objection. Members of this commission will remember that when the State Capture Commission started in 2018, for quite a long time, I would have media briefings where I would invite members of the public who had information about corruption and state capture to come forward. And in particular, I would emphasize current ministers and past ministers and deputy ministers and DGs and former DGs. I would particularly mention those in those media briefings and say, if you have information, please come forward to assist the commission. Members of this commission will also be aware that at some stage, I complained that I didn't think that all the DGs and ministers and past ministers who had information had come forward. Because although some had come forward, my view was there must have been many who had information, but for one reason or another were not coming forward. Now, Mr. Arthur Fraser did not come forward in 2018 in response to that call. He did not come forward in 2019 in response to those calls. He did not come forward during the first half of 2020. He came forward after certain witnesses from SSA or former members came forward and gave evidence. And then when he came forward, he said he has information that is very relevant for the commission, and he would give the information, but he needed a lot of documents from the State Security Agency. I think he said that the information he had would, I think his counsel announced at the hearing, would show the involvement of judges in state capture and corruption, as well as, he said, past and present presidents of the country. So we said, no, that's fine. So he applied, he said he was writing to SSA for documents. And at a certain stage, that is now, I think last year, March, he brought an application for an order that I compel SSA and the Minister of Security to make available to him a number of documents. But the State Security Agency came forward and responded to the application and said, we are prepared to give you the documents you want, but we are not sure what documents you are looking for. You must identify them and follow the procedures. You have been DG of SSA, you know what the procedure is. So you must follow it. And he agreed, he accepted that offer. So I didn't have to make any ruling. And subsequently, and this is contained in my ruling in regard to his application for leave to cross-examine certain witnesses, he was supposed to meet with State Security Agency to identify those documents and obtain them, because he said the statement he had given to the commission is not complete. So it would be complete once he had got that information. But the evidence is that he never went to the State Security Agency to obtain those documents, despite the fact that they invited him to the State Security Agency so that he could see them. He had agreed that he would follow certain regulations that apply in this situation, but they said he didn't comply. He has never explained to the commission why he didn't follow up, why he did not comply with those. So I looked at his objection now, and I thought this time, because he wrote this objection after I had written my ruling on his application for leave to cross-examine, and I'd raised this issue of why did he not pursue the issue of getting these documents that he said were so crucial for his evidence. I thought that when he objects after that ruling was out, he would explain that, but he doesn't. So it remains a mystery why somebody who said there are these documents that are so crucial, which will help the commission, didn't pursue them. So the fact of the matter is, one, therefore, all that he had given the commission was an incomplete statement on his own version because he needed those documents. He has not said that he can do any other way to complete it without them. But two, he seemed not to want to play according to the rules of the commission. The commission has certain rules. If you want to do this, this is what you do. So that is the position. When his legal team was before the commission, I think in April, I said to them, I'm postponing this application sine die, that is without fixing a date, but I don't want you, when you come back from getting those documents, if you come back and find that we no longer have time as the commission, I don't want you to say, why did you allow us to get the documents if you were not going to have time? I said to them, when you have got the documents, we will look at what is possible at that time. And he never came back to say, here are the documents, or I'm abandoning the documents, but my statement, I can complete my statement. He didn't. I hope that has covered those that you addressed.
Yeah, there's one about B. Swane, acting president. That was the third one.
I don't know if you are able to remind me. I can't remember what it says.
Through you, acting president. Well, B. Swane is a generalized objection, but I think one of the things he says that three of the applicants that appeared before us are constitutional delinquents, including yourself. So I don't know if you want to respond in any great detail to that.
Yeah. Well, some of them I had dealt with. I dealt with when, at the stage of the panel, we provided answers, which I assume have been made available to the commission. But obviously, if any member of the commission wants us to go into it, I can look at it and then I can deal with it. But I had provided answers, I think, for all of those, if I'm not mistaken.
Thank you, acting president.
Thank you, Commissioner Singh. Acting Chief Justice, might I appeal to you? We're approaching 1 o'clock now. Whilst you have the right to answer adequately to all the questions put to you, you should please endeavor to keep your answers succinct. Thank you.
Thank you, Chairperson. I shall endeavor to do so. But of course, these were 3 or 4 questions that came from Commissioner Singh, but I will endeavor to do so.
Thank you very much, Acting Chief Justice. There is a follow or follow-up questions from 3 of the commissioners gathered here. Professor Slema?
Thank you, Acting President. Good afternoon, Acting Chief Justice.
Good afternoon.
The question that was put to you by Commissioner Singh concerning the objection that you are in favor of President Zuma, not President Zuma, President Ramaphosa, links up to a question and a certain uneasiness that I feel to think about you as chairing a commission who has to decide on the credibility of the president and also whether he's guilty of certain actions that are not appropriate. The same precedent that you have to decide upon is the person who may be appointing you if you were to be appointed as the Chief Justice. The other thing that comes into play is the fact that the report is not finished as yet. What can you say to this?
Well, Commissioner Slema, the truth is that in the work of the commission, the president gave evidence, and like every witness, his evidence will have to be weighed up, assessed. I haven't gone to that, to dealing with most of his evidence, and I will have to make findings. But as I said earlier on, with this job, you have got to do the job, make the findings you make, accept that you may make enemies, but also accept that you may make findings against anybody, including the president. So if there is enough evidence that justifies a finding against the president, that finding will be made. But no finding will be made against the president if there is no evidence that justifies it. Just as with regard to former President Zuma, where I've made any finding against him, I've done so because there is evidence. But where there's no evidence, I will not make any finding against President Zuma when there is no evidence. I will not make any finding against anybody when there's no evidence, but I will make a finding against anybody if the evidence justifies it.
So
and if I must suffer any consequences for that, it's fine.
So that should then say that we shouldn't read anything into the fact that that part of the report is not finished yet.
Well, Abba, I don't know what you have in mind, but the report, the idea, as you will recall, and everybody would recall, the idea was to complete the report by end of December, the entire report. That was the plan. It was only when it transpired that it was impossible to finish the entire report by end of December that I then decided that let me rather do it in parts. And the reason for that was that I just thought, sure, the country would be up in arms if I said I'm not handing in anything at all by end of December. So I said, at least it's better if there is a part that we hand in. But my plan and the plan of the whole commission, we were working flat out to finish the report, the whole report by December. And I actually, when some of the members of the legal team at some stage tried to say to me, I must start entertaining or thinking about the idea of making an application for an extension beyond December. I didn't want to hear that because I wanted to finish in December. But there came a time when I had to be realistic and accept that I was not going to finish the whole report in December. And then the next thing was, do we then tell the public, the nation, we are not submitting anything until it's everything? But we said, we have done quite some work So why can't we do it in parts? And we agreed that let's have part 1, part 2, and part 3. So nothing else should be read into it.
Thank you for that, because some people can think that the reason for the report to not be completed is kind of, you don't want to blemish the possibility of being appointed as the Chief Justice.
They don't know me if they think like that.
Thank you, Chair.
Thank you.
Thank you, Professor Slema. Commissioner Magwanishe, a quick follow-up.
Thank you very much, Acting President. Good afternoon, Acting Chief Justice.
Good afternoon to you, Commissioner.
It's just one question, and I think for the benefit of the public that would not have some of the documents you are referring to. I do understand the part of the cross-examination with respect to former DG Fraser, which is part of the objections. But you have allegations against a person to the tune, I think in the allegation is about 9 billion rands. Didn't you think that it was prudent that he should be summoned to appear?
Well, I can't remember the amount, what the context of the amount you are talking about. But in the commission, there was at some stage a figure that was mentioned by some of the SSA witnesses, which was incorrect. And it was corrected that, no, that's not correct. So you may be talking about that figure that was incorrect. But let me say this. You have somebody who says, I will tell you the whole story. But these statements that I'm giving you are incomplete. The whole story, the other part of the story is in documents. And the documents that he listed were many. I think the list was something like 11 pages, were many. So when you read, when you see that, you see that the documents constitute a big part of the story, you know. So the question then is, what's the point of hearing this evidence when it is not complete? And you bear in mind, as I've said, that this person tells you in the 3rd year of the commission that he has this information about state capture and corruption, which involves high people, people in high office. And he says he knows you have been calling for them people who have information to come forward. But for 2 years, 2.5 years, he didn't come forward. So you say, do I, at this late stage of the commission, hear this evidence that's incomplete? What would be the purpose of hearing it if it's incomplete? What will I do with it if it's incomplete? And you are actually outside, or you are basically on overtime, because in March, when he came before the commission applying for an order from me compelling SSA and the Minister of State Security to compel them to give him these documents, we were due to, I think we were due to finish at the end of April or March, I can't remember, but we later applied for an extension. That is why I said to his lawyers when they were before me, I don't want you, when you come back with the documents, to complain if at that time I say we no longer have time, because you will say to me, what was the point of you allowing us to go and collect all of these documents if you are not going to hear us? I said, So go and collect the documents, but when you come back, depending on when you come back, we will look at the situation at that stage because we are already on extra time. And as it happens, he never came back. The next time I heard from him, I think the commission sent him or his lawyers a notice to say, please make written representations about A, B, and C, which he did. And then the next thing was when he lodged an objection. But he has never had the courtesy of coming back to the commission and say, Chairperson, you remember in March I came to you, I wanted you to force SSA to give me documents and you allowed me to go and get them. This is what happened. He has never done that.
Thank you, Acting President.
Thank you, Commissioner Magwanisha. Yet another follow-up from Commissioner Mapisa Ngakula.
Thank you very much, Acting President. Good morning.
Good afternoon, Madam Speaker.
Good afternoon, Acting President Zondo,
Sorry?
Acting Chief Justice Zondo. No, my follow-up question to you is on the very matter which has been raised by both Honorable Singh, Commissioner Singh and Commissioner Magwanisha. The issue for me is I've read the entire objection by Arthur Fraser. And I'm fully aware that there are documents which he requested from State Security, which finally he himself did not make himself available to get those documents. Now, between what happened to SSA and State Security and Arthur Fraser, that's another matter. The question I have is, the allegations against Fraser were damning allegations. Whether it's equal to 9 billion or 1 billion or 500,000, but the point is they were damning allegations. And I know for sure that there are many people who were summoned or subpoenaed to appear before the commission to present their side of the story on whatever had been presented about them. The question is, didn't the commission see it fit that with all the toing and froing between Arthur Fraser and State Security and Arthur having approached you and said he would want to appear and you and him wanting more information. Now, at that point, would it not have been incumbent upon you to say, look, we've given you time, you were here in March, we're moving towards the end of everything. We're wrapping up the commission. And the allegations which have been presented here to this commission against you are damning allegations. And therefore, we are now summoning you to appear before the commission to answer for yourself or to explain or to whatever it is, but for you to be able to raise all of the issues you would have wanted to raise directly with him. Not that the commission was a court of law. Obviously, certain things are going to happen beyond this. But with everything which have been raised about state security in particular, honestly, don't you think it would have been proper to say the accounting officer at that point, whose allegations against him were really weighing very heavy on everybody, should appear before the commission, should answer for himself or present his side of the story to the commission? Thank you.
Thank you, Madam Speaker. Let me put it this way. the rules of the commission say if somebody has given the commission an affidavit or statement which implicates somebody else, the commission must issue what we call Rule 33 notices. The Rule 33 notice tells you, the person who is implicated in that witness's statement, that there is this person who has given the commission a statement that implicates you, and here is that statement that implicates you, or here are portions of that statement that implicate you. And then it says, the notice says to you, if you want to challenge this evidence, you must apply to the commission for leave to give evidence or to cross-examine the person. And when you apply, this is what you do, okay? Now, what that does do is that it gives you, the implicated person, an election. You can decide that you don't think that this witness implicates you, or his or her statement implicates you, and therefore you do nothing. Or you can decide that even if it implicates you, you don't want to challenge it, you don't care, and then you do nothing. Or you can decide that you just want to give the commission an affidavit that sets out your side of the story without you wanting to give evidence orally or to cross-examine that person. You have an election, you can do any of those things, okay? Now, there are many people, thousands if I recall correctly, maybe over 3,000 people who were served with 3-3 notices by the commission. Of course, we did not hear 1,000 witnesses. So there are many who decided that they did not want to challenge what those witnesses were saying about them, and they did not want to cross-examine them. They just left things like that. Now, some of those, okay, let me first say, if you decided not to do what the rules say you must do if you want to challenge what has been said about you, if you decide not to do that, you can't complain afterwards and say, I was denied the opportunity of putting my side of the story, because the rule, the notice that the commission sent to you told you that if you want to challenge this evidence by this witness, this is what you must do. And you decided not to do anything. So you can't complain that you were not given that chance. Then in that event, but the fact that you have chosen not to do anything did not deprive us as the commission of the power to compel you if we think we should compel you. Okay? That is why there are people that the commission compelled to come before it and answer certain questions. But part of the problem with Mr. Fraser was that he seemed not to want to comply with the rules or processes of the commission. If he wanted to testify, all he needed to do is to apply, and his application would have been decided as many other people had applied and they were decided, he says, I didn't want him to testify because his evidence would disturb the narrative that I wanted to follow. But the best way for him to test that would have been for him to apply for leave to give evidence and see whether I was going to refuse. Because if he applied and complied with the rules of the commission, the matter would come before me in open court and in an open hearing, and then I would have to make the decision. He decided not to do that, but to want to be treated outside of the rules. But more than anything, the problem with Mr. Fraser was the time when that kind of decision could be made. I could not make that decision in March because in March he still wanted to get documents from SSA. So, and he never came back to me to say, I didn't find the documents or I don't want to use them anymore. So by the time when he complains that I didn't call him, when we look at that time, we've got to look at the last part of 2021, when the oral evidence had been completed in June. So if I were to have decided to call him after I got to know that this route of getting documents from SSA was not being pursued, it would have meant that I would have had to reopen the hearing of evidence maybe in October. And then another complication with him was that he could implicate a lot of people who had previously not been implicated, which would then mean we must give those people opportunities, and we were running out of time. But if he had approached us in 2018, when I made that call to say all DGs past and present and ministers and deputy ministers who have got information that is relevant to the commission must come forward, there would have been enough time to deal with all of this. Thank you.
Thank you, Acting Chair.
Thank you, Madam Speaker.
Thank you, Commissioner Mapisa Magula. Commissioner Malema.
Thank you, Acting President and Deputy Chief Justice.
Thank you, Commissioner Malema.
I think that we hear each other very well, and the answer you are giving, which is so long, is deliberately trying not to answer the question on Fraser. The question on Fraser is not what he has done or he has not done. The question on Fraser is, it's an accounting officer of an institution that got highly implicated, and figures and amounts of money were thrown around, whether this or that amount of money. It is immaterial. Why didn't the commission compel him to come and answer as a former accounting officer? Not what he wanted to do on helping the commission. No, that is his part, which he has not done. We have no problem with that. Fraser and the institution he was leading gets implicated in the commission. Amounts of money gets thrown around. Zizi Gotwa gets called for 1 million rand. Here is a person who was leading a strategic institution of the state, and that institution is implicated. Zizi Gotwa did not lead any strategic institution of a state. Didn't work for government. He worked for the ANC. He gets called, come here, your name is here, we were told you got 1 million, come and tell us. Yeah, Fraser gets implicated, monies are thrown around from the state coffers, and he's not called and compelled to come and answer on those allegations made against both him and the institution that he has led. Why?
Well, Commissioner Malema, the question has been answered. Let me repeat. In March, Mr. Fraser said, I need documents from the SSA to give you a full picture. I want to give you a full picture. Okay? So at that stage, there was no reason to think that he would not pursue that route of getting all those documents that he said were so important for him to, because he said it's for him, they will help him to respond among allegations against him. Okay. Then he goes away with my permission to say, okay, this application that you brought, that I should compel the state security to give you these documents, we put it without fixing a date. And I even said, if you don't come right, you can come back. I was talking to his lawyers, obviously not to him. If you don't come right, you can then come back to me and revive this application, and we can take things from there. But I said, I do want you to know that we are running out of time. When you do come back, we will assess the situation at that time. He never came back. And if I were to decide whether to compel him, I would have to have made that decision maybe in October, maybe in September. And that was too late. But I had warned him or his lawyers that when you have received the documents and you come back, you must know that we will assess the situation at that time to see what is possible and what is not possible. So we didn't call him, partly because his story was not complete, because he had said he needed the documents. He had said to us he needed those documents, he would go and get them, and we expected him to come back. He never came back. Actually in June, and the case it was 17 June, if I'm not mistaken, the Secretary of the Commission wrote both to his lawyers and to the lawyers of SSA and said, effectively, what is happening about the documents? And his lawyers did not respond. The state attorney representing SSA is the one that responded and told and said what was happening. So if any decision had to be made, it would have had to be made maybe in September or thereabout, which was quite late.
DCJ, there are two types of people the commission deals with. There are people who got called upon, former ministers, DGs and ministers and all, who must come forward to help the commission if they can and bring whatever information they want to bring. And Fraser came late with regard to that. And even when he came, he said, there's these documents I need to help the commission. I understand that. Then there are these ones who get implicated in the commission, where the commission realizes, no, this one will have to come and answer this, not these things that he wants to give us. This one, hear you, we want you to come and answer on these ones. An initiative. The commission takes the initiative. Did you do that with Arthur Fraser when he got implicated and write to him and say, come here, the following things are implicating you, we want you to come and answer?
Give me a moment, Acting Chief Justice.
Oh,
Commissioner Malema, could you please try and moderate the tone of your voice? Thank you.
No, I don't understand that. I speak like this. I must moderate what? I speak like this. This is how I speak.
Now, Commissioner Malema, you are shouting now, not speaking.
No, but Chair, I speak like this. I can bring all types of videos you want to see of me speaking. I speak like this. I'm not fighting. He chairs these meetings all the time. He knows I speak like this. I'm not fighting.
For the sake of progress, shall we please give the acting Chief Justice to respond to your
Please.
last question?
Thank you, Chairperson. You see, Commissioner Malema, there are people who were implicated, and there are many of them, whom we did not call, even though they were implicated. On their side, they decided they were not going to do anything, even though they were notified that they were implicated. And we ourselves decided not to call. Okay? There are many of such people. But there are some that we decided, but we must call this one. And that depended on a number of things. One of which would be when we still had a lot of time, we could call a lot of people. So what I'm saying is, first, after you have served the notice, Rule 33 notice on an implicated person, you wait for them to see whether they are going to make an election to apply for leave to testify, or for leave to cross-examine witnesses, or for both. After some time, if they have not done that, you have to make a decision whether you must call them nevertheless, even though they didn't say anything. And some we called, others we didn't call. But with regard to Mr. Fraser, what I'm saying is, before March, there was no reason to force him to come to the commission, because in June or July 2020, he had come to the commission with his legal team and said he wants to give evidence. He has a lot of evidence, but he wants certain documents from SSA. So he was going to come back, and we had no issues with that. But until March, we didn't know what was happening, but we were clear that he and his counsel were very emphatic that they would come back. He wanted to testify, but he wanted certain documents. And then in March, he applies to me to say, compel SSA and the Minister of State Security to give me these documents that are so important for me to respond to these allegations and to tell you about state capture and corruption in general, I think. So I say, okay, but we are on extra time. When you get them, we will see what can be done. And he never comes back. By the time I could have made any decision to say, okay, he's no longer come back, it would have been about September. It would have been too late. And my view would have been, it's so late, his evidence might not just, well, first of all, he said those documents would help him also to respond to these allegations by these witnesses. So he would probably implicate other people, and then who would want to come, and the commission was required to complete its work. So that was the situation we were faced with.
Chair, but my problem here is that he says he's implicated in a 9 billion, and you say there's a different figure. Surely, the commission that is investigating corruption can't miss to compel a person implicated in a 9 billion scandal from state security where there is slush fund and some of which is not even accounted for. This would have been an opportune moment for the commission to expose the rot that has constituted some of the activities in that institution. So I hear that, but my problem is that you still don't call him on your own to come and account for 9 billion, because I'm telling you 9 billion, that's what he says. He says in his objection, I'm implicated on 9 billion. And I'm shocked I'm not compelled to come and answer on this 9 billion.
Well, you see, Commissioner Malema, one of the things we had to accept, certainly I had to accept as chairperson of the commission as we went along. I mean, there were many issues that I would have liked the commission to pursue. But I had to accept that I am not the only one. Anything that I've not investigated, it doesn't mean there's nobody else who can investigate. I must accept that there are other people who can do the job and other agencies. There was pressure that the commission must finish its work. And you might have seen when I applied for extensions, how there would be complaints about this commission is not finishing its work, and there were challenges about money. So we needed to make a decision. And certainly I would have said, look, one, we have evidence that implicates him in a certain way. He has been given an opportunity, if he wants to challenge that evidence, to comply with the rules and apply, and then that application would have been decided. He chose not to do that. So he must have had a reason why he didn't want to do that. And he certainly had lawyers, and the lawyers he had knew the procedures of the commission. So he might not ultimately account to the commission, but the evidence that has been led before the commission will be available to law enforcement agencies and to other people. He might end up accounting anyway. So I mustn't prolong this commission as if I'm the only one who can investigate everything.
On a separate matter, the courtesy to President Ramaphosa to come and account, let me understand, how did that come about? And in terms of the rules of the commission, which rule is that? Is that one?
Well, it wasn't in terms of any rule of the commission. Remember that this commission, the commission is a presidential commission. It was established by President Zuma. But once he left office, basically it gets inherited by whoever the president is. So it's a presidential commission. One of my obligations is to update the president as to how the commission is doing, which I was doing. So I would meet with him from time to time. I would meet with him when there were, for example, challenges about budgets. There was a time, some of the commissioners may recall, when it was in the media that investigators and the legal team had not been paid for a long time. There was a time when Treasury was not giving us money, and Department of Justice was not giving us money. And it had gone on for a long time. I realized that if something had to be done, I needed to speak to the president, because the next thing, the legal team and the investigators would leave. You know, it would be unreasonable to expect them to continue working without being paid for I think at some stage they had not been paid for 3 months. So I had an obligation to meet with him regularly and appraise him about what is happening and what challenges there are, where I think he should come in, because it's a presidential commission. But then I also said, you will have to come and testify before the commission finishes its work, and he agreed.
According to which rule do you have to brief the president from time to time about the work of the commission? Because if the president has established a commission, that's it, because it might be seen as if you are now compromising the independence of the commission by constantly briefing the president, whereas if the president is also an implicated person in the commission's work.
Well, the rules of the commission talk about the proceedings of the commission. They don't provide for everything. They don't deal with everything. You know, they basically provide processes how certain things are done, how witnesses come to the commission. So they don't deal with that. But my understanding is that judges who have headed other commissions would do that. They keep if it's a presidential commission, you keep the president informed of the progress of the commission. If it's a commission established by a premier, you keep them informed how everything is happening, is going, and if there are any challenges, you update him.
How would you
Commissioner
respond?
Malema,
The
excuse
last
me.
one, last follow-up on a separate matter.
Okay,
Yes.
very last one. Thank you.
The release of the last report, which is likely to implicate the president, is that not a sword on the neck of the president that he must appoint you, or if he doesn't appoint you, the report is likely to go a different way? Because there are two parts of the reports which were released. Why was the president's side not included in the reports which were released before this interview? Because we're human beings and we're politicians and we're political animals. If you have a report on me and you don't release it, and I've got certain obligations towards you, I might be tempted to do the right by you. Otherwise, I will be dealt with wrongly. So, how will you respond to this? That this serves as a sword on the neck of the president, because if he doesn't do the right thing, the report is likely to go differently. Thank you, Chair.
Well, interestingly, I never thought about that angle, Commissioner Malema. But I think the reason why I never thought about it is it's because of how it came about that we decided that the report would be in 3 parts. And how it came about was that for a number of months before the end of last year, we were working flat out to complete the whole report by end of December, because the order of the court that had granted us an extension had given us up to the 31st of December. That's number one. Number two, I wanted to finish the work of this commission. I mean, for 4 years, I've been doing this, the work of this commission. I haven't had much time to rest. I haven't had much time for my family over the 4 years. There are times when I've worked right around the clock without sleeping to try and push the work of the commission. If there's one thing I would like behind me, is to finish the work of the commission. So towards the end of last year, I was pushing everybody, saying we must finish. So when I realized that we were not going to be able to finish the whole report, we looked at what portions of the report would be ready by end of December to release. And those happened to be the ones that were in part 1. And the ones that are in part 2 were those that were closer to being ready. So there was no conscious decision to say, oh no, that part must come later because of what. It was simply which parts were closer to being ready by a certain time in December, and saying there is no way we can face the nation and say we want an extension, but we are not submitting anything. Let us submit something at least. That was the idea. Thank you, Commissioner.
Thank you, Chair. Thank you, DC.
Follow up.
Thank you,
Follow up, Acting President.
Commissioner Malema. Commissioner Nyambi, please bear with me, Minister. I had Commissioner Nyambi long before you.
Oh, okay.
Thank you.
Thank you, Acting President. Afternoon, DCJ.
Good afternoon, Commissioner.
It's one follow-up from my part, taking it from the question of Honorable Singh. I don't want to misinterpret what you are telling us, so that when we are having deliberations, it's used against you. You said you knew when you were identified to lead the commission that will create enemies. So I asked myself a question, that how Is that possible? Because you had a clear and objective mind. It was possible to get it there and only to find that there was no corruption. So I want to have that understanding that how can you
Yes.
create enemies
Yes.
before you can get the actual commission starting its work and get the road that was happening in the country.
Yes. No, I think what I mean was you can't run a commission like this without a situation where at some stage or another you are going to make rulings against some people. You might have to make rulings against people in relation to actual corruption. But obviously, at that stage, I didn't have the evidence. But I know, as much as all of us know, that South Africa has had a high level of corruption for a long time. Leave out state capture, just corruption. And remember that the commission wasn't looking, in terms of its reference, was not just going to look at state capture, it was going to look at corruption as well. And therefore, it's highly unlikely that you would have this commission in a country that is so full of corruption, and you would think that you would not find any evidence and make findings of corruption against some or other people.
Thank you, TCJ. Thank you, Acting President.
Thank you, Commissioner Nyambi. Honorable Minister.
I just want to check, Acting Chief Justice, you applied several times to court for the extension.
Yeah, yes, I did. And I must tell you, Minister, that each time I didn't like this idea of applying for an extension. Actually, initially in 2018, I thought it was the president who should apply because it's his commission. But he got a legal opinion that said I must apply. So I had to apply. So I've been the one applying all the time and the one taking flack.
Yeah, so obviously, most of the time when you had to apply for the extension, you will have to talk to the president or sometimes to the minister because there will be implications on the work of the commission.
Yes. Certainly, my approach was that this being a presidential commission, the president should not hear it from the media that we were applying for an extension. And obviously, the minister and the department were supporting the commission, and they also needed to hear. But most of the time, I dealt with the president.
Yeah, and sometimes there could be budgetary issues that, for example, the department will have to consider and advise the president, vice versa, and the commission.
Yes.
Including you talking to the president about these budgetary challenges that
Yes.
the commission is dealing with.
Yes.
No, thank you.
Thank you.
Thank you, Minister Lamula. Would the members of the commission allow me to take Mr. Nokesi before the lunch adjournment? Thank you. Commissioner Nokesi.
Thank you, President. Good afternoon, Acting Chief Justice.
Good afternoon, Commissioner Nokesi.
Firstly, I must record that the four of you as the candidates, you are role models to me.
Thank you.
And we have done a lot for this country.
Thank you.
It's worse for you writing more than 200 judgments. That is prolific writing with articles and publications.
Thank you.
So whatever questions I ask either from you or other candidates
Yes.
are genuine, there is nothing.
Yes.
Obviously, we just want to clarify issues.
Thank you. Thank you.
Yeah. Now, from your presentation, what I must appreciate again, you gave a detailed insight to the Constitutional Court, the workings of that court, the challenges, and therefore I have a better understanding of that court, and I must commend you for that. I definitely have no much questions to ask you in relation to that.
Okay.
We have to discuss in relation to your capacity as the head of the judicial. And even there, I must break it down to the leadership. I think that's where we'll focus on. And to begin with, my question is, would you consider your appointment to the commission as the chairperson as part of your leadership enhancement, as part of your leadership, which must be considered in the context of you becoming the Chief Justice?
I'm sorry, I keep on forgetting that I don't have to press here. Thank you for that question, Commissioner Nochesi. Yes, I consider that when you, honorable members of this commission, consider my candidacy, you should consider the question of my chairing of the commission.
Yes.
I say so knowing that some criticize me about how I chaired it, others like how I did it, but I think either way it's fair.
Yes.
And so yes, I think it should be considered.
Yes.
Thank you.
Now, the first question I want to, is from my experience. In the Eastern Cape some time ago, a commission was established. It was headed by the late Justice White. That commission, after it was concluded, litigation arising from it lasted for more than 10 years. There were many, many cases. The chairperson here may attest that at some stage, I think he was one of those involved in matters arising from that commission. So do you agree that any commission is likely to end up in court with reviews, all those involved being called upon to give evidence, testify? Do you accept that?
Here is what I accept, Commissioner Nochesi. I accept that after the commission has completed its work and submitted its report, there may be a number of people who launch review applications.
Yes.
Those review applications are normally decided by the courts on affidavits.
Yes.
Without the need for oral evidence.
Yes.
So that I accept will happen.
Yeah.
But I also need to say that the commission or commissioner would decide whether he or she wants to oppose a particular application or not. He or she might decide, I will abide.
Yeah.
Let the court decide. So he or she might not be so involved in those cases after the commission has finished its work, because he or she takes the attitude that my report speaks for itself and I'm not going to be involved.
Yeah.
So, but sometimes, commissioner might decide to oppose. It could happen, yeah.
Now, the commission, that is the State Capture Commission report, like all the other commission reports, because people have been implicated, everything has been made, it will be challenged in court. I mean, that's a realistic chance.
I agree. And I would not be surprised if, before I even filed the first part of the report, I would not be surprised if some people had prepared papers, they are ready. They're just waiting to get the report, complete the papers and lodge.
Yeah.
They will be, yeah.
Yeah. Now, obviously, if that is so, whether you will decide to abide, whether you will decide to oppose, you will be involved in litigation as the chairperson of that commission in the next 6 months, 2 years. In fact, as I indicated, based on my experience, The next period from here is you being involved in court litigation in your capacity as the chairperson of the commission. Whether you say, I don't oppose or you oppose, but definitely that is going to happen.
Well, let me say this, Commissioner Nojesi. If, for example, I'm not opposing and I'm abiding, that means my name is there, but otherwise it's not taking my time because I'm not filing any affidavit. I'm not opposing. So, and you will have seen, I hope, from part 1 and part 2 of the reports that we are giving detailed, we analyze evidence quite extensively before we make findings. And therefore, it would be easy for me, for example, to say, look, we have analyzed evidence, the reasons for the findings are there, let the judge decide. So I don't know what decision I will take, but I'm simply saying there are different scenarios. If I'm not opposing, those applications would not involve my time.
No, so that I pass on from this point. The point I want to make to you, Acting Chief Justice, is that in appointing you as the Chief Justice, this commission, yourself, and all of us must understand that we will be appointing a Chief Justice who is likely to spend a greater part of his time either opposing court cases or risking of the report, of which more than 2 billion has been spent, being set aside because it's not opposed.
You must be careful, Commissioner Nojesi, not to send the message to other judges.
Yes.
That if in the future there is a need for a judge to chair a commission, they say, hey, I don't want to agree to chair this commission because after the commission, there will be there will be reviews and I might not be, that might affect my career adversely because now it will be said I will be involved in all of those things. We want to encourage judges when they are called upon to perform this kind of function to consider it favorably because it's an important job, duty for country. So one, I don't think it's the kind of thing that really should be a problem. And one, I might not oppose, partly because we give detailed reasons why we have come to certain findings. Two, it might be that we say, well, let the court decide. And maybe there will be other people who will oppose. Yeah, thank you.
Look, I mean, what exactly you get my point. It is undesirable in any country to appoint a sitting judge to impact, especially the head of the court, such as the Chief Justice or Deputy, to chair a commission of inquiry. And that I will demonstrate to you by what now has followed up. I've read no less than 8 objections against you. 2, there is this possibility which we both of us agree of the matter taken to court, remaining there over some years, because go to the High Court, appeals, it's the next 5 years, and your period left as a Chief Justice is 2.5 years. This is a risk that, to me, from day one, ought to have been avoided. And you do say, so that I want you to answer holistically, you do say some judges were phoned, were called. But why did you not simply appoint a retired judge to deal with this? Take all the evidence, because you won't have the complaints such as those of Fraser. They would not have much time, complaints and all those things. Just one reflection as a leader. I'm asking you this question on the basis of your leadership in relation to this decision, to me, which was critical and it affects us now.
Well, one, you will recall that I said we called a number of judges, and I can't remember whether it was one retired judge or it was more that we called. But when I realized that the Chief Justice could turn to me, he was speaking to a retired judge because we were trying to get a retired judge. President Zuma had said to him, this matter is urgent. Chief Justice needed to go back to President Zuma without delay. So after our efforts had failed with a number of judges, he turned on me. And I took the view that as part of the, I would have preferred to continue in court as Deputy Chief Justice. I had not finished a year having been appointed as Deputy Chief Justice. I enjoyed the court work and so on. But I took the view that the country needs somebody to do this job. The Chief Justice of the country has tried to get other judges, but now he has turned to me. I can't say no. That was my approach.
And there is this complaint of, which is worrying me, complaint of this Tabom training, which relate to the recusal application brought by Mr. Zuma, where I will just read. Acting Chief Justice Zondo became a witness and was also a judge for the same recusal application against him by former president. He gave his version of events against those raised by former President Zuma and later gave an order against former President Zuma. That's how he summarizes.
Yeah.
I don't want to get into the business of this. But what I remember, I don't get it. If it's not so, correct me. There was an application launched pursuant to this for review.
There was a?
Was there any application for review launched pursuant to that recusal?
Right. Yes, there is a current pending review application against my decision not to recuse myself.
Yeah.
Yes.
Now, you are the Chief Justice there. That case will go up to the Constitutional Court. And they will go even if it's on another court, from somebody outside there sitting objectively. Here is the Chief Justice who is accused in the manner that it is set out here. And they will have to make a decision because they say you gave evidence, whether right or wrong, that's what they say. The court has to decide now about which version to believe, yours and that one of the. Look, is it not a very awkward situation in the form of a Chief Justice? That is a point, emphasis that I want to make.
And let me just understand, is the question directed at simply that I refuse to recuse myself in circumstances where maybe other people might think I should have, or is it that I have a certain version which is different from that of President Zuma?
No, let me simplify. It's all about the desirability of a Chief Justice or the leader of the court being involved in litigation and the implication to the colleagues vis-a-vis the public perception. That's the
Well, let me say, we have a very independent judiciary. You will recall, if you did get a chance to read the first judgment of the Constitutional Court, in where the Commission asked the Constitutional Court to issue an order compelling President Zuma to appear before the Commission. You will recall that my colleagues in that judgment did criticize me. They said I had been too, as I recall, I'm putting it in my own words, I'd been too soft on President Zuma. So I have a situation where my own colleagues said I was too soft on him, and other people say I've been harsh on him. So the point I'm making is that, one, my colleagues would not be deterred from making whatever conclusion they need to make just because I'm one of them. And you have seen in the Judicial Conduct Committee, judges have made decisions against other judges. There was a judgment against Judge President, there was a judgment against Chief Justice. So judges seek to do their job the way it should be done, irrespective of which judge, what is their position in the judiciary. They try to do that.
The other criticism, going past on this one, the other criticism during the proceedings, in what ultimately resulted in some complaint in the scuffle between Mr. Pofu and some other, you hold a conference about the proceedings of a commission. Instead of making a ruling there, the matter ends. But you have to hold conference. Is it something normal that if a DC is being chaired, a DC, an inquiry, a court hearing, one of the lawyers misbehave or one of the parties, that a judge must go and actually call a press conference about what is going? Is it something normal?
Well, you see, Commissioner Nujesi, different people would have handled this commission differently.
Yes,
Okay?
yes, I agree.
Maybe somebody else would have handled the matter differently.
Yeah.
This is a commission that has a lot of public interest. And what happened publicly. And I don't think that I should have dealt with the issue privately when it had happened publicly. I thought I should deal with it transparently. That's what I did.
No, my point is not, the commission was public.
Sorry?
The commission was public. We could watch all of us. The issue here, my take is the press conference.
Yeah.
Because you called for a press conference
Well,
about your ruling and your decision. Is it a normal thing by judges or chairpersons?
Actually, now I remember. I don't think I called a press conference.
Okay.
I simply made remarks or made a statement from the commission hearing where the event had happened. I think after 2 days, after I'd reflected on it, I didn't call a conference, a press conference, but the proceedings were broadcast, yeah. But I didn't particularly call.
No, I'm sorry
Yeah.
to say you called for it.
Thank you.
Now, the last aspect. With all these complaints, like we turn to you now as the chairperson of the JSC.
Yeah.
Because that's your role as the Chief Justice as well. Out of these objections, I'm right or wrong, I did not look onto the demerits and merits. Do you know if there are complaints that have been filed against you? Is there anyone who has filed a complaint? Or is there any complaint against you arising from all that work?
Well, there is no complaint that I'm aware of that is currently pending against me. There were complaints at some stage before which were dealt with. As far as I recall, as far as I know, there is no current complaint pending. Yeah.
The complaints that were filed arising from the commission were filed, but they have been dealt with.
There was, as far as I know, only one that arose from the commission. It was filed by Mr. Montana. It was dealt with and it was dismissed. He didn't take it further.
And you were the acting chairperson of the sub of the JCs at the time, but you just have to recuse.
Yes, I did not
which
take
is
part.
normal.
Yes, I did not take part. Yeah.
And if there are others that will come arising from all these things, an awkward situation is that it will affect your participation there because they will be coming, we don't know. Because I'm looking on the number of objections, if there are anything to go by.
Well, firstly, those people have made objections here, but have not lodged complaints with the Judicial Conduct Committee. I don't know whether one of them may have lodged a complaint before and it was dismissed. I can't remember. But as things stand, I'm not aware of any complaint that they have lodged in the JCC. Yeah.
Last question. Is simply on the model that you discussed with the minister of the OCJs, of the OCJ, as the department.
Yeah.
It's a pity that you present, and I listened to Judge Mlambo even yesterday, you presented the document which has been agreed by the judiciary. This is what they want. Can't you consider the implications on the independence of the judiciary? Because once you have this department, I know you want to come with councils. You say there must be councils. Bypassing what actually should happen. Because when you have a department, that department must go to parliament, because parliament must vote for your budget. You must have an administration. Is it not going to bring tensions between the executive and the judiciary? That's one. Two, the public appearance, public perception. When judges spend a lot of time sitting, as it is happening now, I listened to Commissioner Malema and the minister having to explain that judges spend time with the executive, because you have to, once you run you take full administration, because that's what the department entails. Is it not going to impugn or to trample upon the issue of the independence of the judiciary, institutional independence? The one that you think you seek, are you not actually compromising it?
No, not at all, not at all. Actually, other countries have, some countries have achieved that level of independence. The fact of the matter is, even under that system, it is accepted that there would have to be somebody who goes to parliament. For example, phase 2 of that proposal says that the office of the Chief Justice should be established as an entity that is similar to the Auditor General. And the office of the Auditor General goes straight to parliament. You see, it does not like having being attached to a ministry, you know. So what basically is that phase 2 contemplates is that before you get to complete institutional independence, you are going to have that situation. But basically it doesn't mean there will be no accountability, but it simply means everything is within the judiciary.
You agree with this? Would you agree with the statement on the individual independence, personal independence of judges? Would you agree with the statement that the greatest threat to the independence of the judges or of the judiciary is the judiciary itself? Why so? If you endlessly reserve judgments, if you conduct in a manner that people must question, must have question marks, if you enter into phrase or spaces that judges are not ordinarily allowed to enter into, and many other, but the biggest threat to the judiciary is the judiciary itself, on how it must conduct or it conduct itself.
Well, I would not agree that, certainly within the context of the South African judiciary, that the biggest threat to their independence is themselves. But what I would agree to is that the judiciary must be careful not to do things that would actually impact negatively on their independence. The way we behave ourselves, we conduct ourselves, we need to make sure that we conduct ourselves in an appropriate manner. So in other words, yes, there are things that we as the judiciary can do that could impact negatively on our independence, but I wouldn't go so far as saying that we are the biggest threat to ourselves.
Yeah, no, I will make as I've said. If you reserve judgment endlessly, people are allowed, they are free to criticize you. They can even go to a rally and say, our judgment is kept by that judge. They can do that. Two, if you behave in a particular way. For instance, I know this is a call, maybe it might be sensitive, otherwise I must ask, I would not be correct. When you call for the press statement in reaction to Minister Sisulu's criticism, would it not have been simply sufficient if you, as the judiciary, you just write a strong worded statement through the office of the CJ, rather than calling for a press conference, allowing journalists to ask questions, ending up having questions that you don't have to, you are unable to answer at that level. Because the next thing is for Minister Sisulu to call her own conference. And the whole week is occupying the space for a month, debating that drags the judiciary into the public space. Like on a further reflection, I'm not criticizing,
Yes.
it was your call,
Yeah.
but calling the press conference itself,
Yes.
was it an appropriate action?
Well, one, I think it was, but let me tell you how it came about. Initially, I thought one would issue a statement. I think about 5 or 6 days had lapsed since that article had come out, had been published, or at least had become known. I may have known it after 2 days or 3 days about it. Initially, I was thinking I should issue a media statement. This happened in the course of a very busy schedule on my part when I was preparing part 2 of the report, working extremely hard. So at a certain stage, I think I had wanted to issue the statement before lunch, but at a certain stage, I realized that I had not been able to get the statement ready. And it occurred to me that it might only be ready the following day. So, but I was clear in my mind what I wanted to say. So I decided, look, there's already been so many days, so let me just go public and do this. But I took the view that I want to try and limit myself to that which I consider to be an insult. I don't want to get involved in other points.
Thank you, Acting President. But once more, Acting Chief Justice, I must say we are inspired by your work.
Thank you
as a
very
judge,
much.
especially that only you and Judge Mlambo are the only attorneys in this list of 4.
Yes.
And also as an attorney, you have progressed to the stage where you are as the Deputy Chief
Thank
Justice.
you very much. Thank you very much.
Thank you very much.
Thank you.
Members of the commission, I'm sorry to disappoint you. I'm informed that our dining area is crowded at the moment. So we would be well advised to continue for another 15 minutes. So if you would kindly bear with me. Thank you.
Is it possible to get a convenience break?
A comfort break at this stage, Acting Chief Justice.
Well, I was just saying a convenience break, a brief one. I think Commissioner Malema understands what.
No, the chair must understand you better than me.
Maybe I thought if you tell him.
I hear you. He must hear you. I hear what you are saying.
Yes, please.
Well, there is a
Yes,
witness.
shall we then take just a 5 minutes adjournment?
Chair, I will propose we go to lunch. There's nothing crowded. We are all here. We are South Africans. So let's just go to lunch.
I suppose so.
Yes.
Let's reconvene then at 3 o'clock. Thank you.
Thank you.
If the chairperson does not hear you, acting chief, you will have run away from this.
No. I think I know. I must just contact Commissioner Malema. He will make sure he understands me.